Welcome back. In the first mini lecture on the Supreme Court, really the whole point of the first mini lecture is that not only is the Supreme Court a political institution today, and you were hearing about this certainly surrounding Trump's new nominee, but the point that I tried to make in the first mini lecture is that the Supreme Court has always been a very political institution. So keep in mind really the three questions that may appear on the exam, right? The president nominates Supreme Court justices. There is a political component to that. A majority of the Senate is needed to confirm. Obviously, there is a political component to that. And all federal judges serve for life. And even the decision as whether to retire or not has political implications. So that was the theme of the first mini lecture. The court is a political institution in terms of presidential nominations, Senate confirmations, and the tenure of life. I want to continue with the overviews with the second overview, and that is that a president's impact on the Supreme Court is really unknown until after he leaves office. There's no way to determine in advance if a Supreme Court justice is going to retire or die. And so when a president takes office, he may be like Jimmy Carter. President Carter did not get to nominate any Supreme Court justices during his 4 years as president. Carter obviously nominated people to the lower courts, and there are 13 courts of appeals. There are 94 district courts. So there are 107 courts other than the U.S. Supreme Court. So when I'm talking about the courts, I'm emphasizing the Supreme Court. That does not mean all presidents are going to get to nominate federal judges, especially to the U.S. district courts, which are at the bottom of the federal court system. But a president may not nominate anyone to the Supreme Court. And Jimmy Carter is the last president who did not get to nominate anyone to the court. The other extreme is obviously a president may nominate the whole court. When Franklin Roosevelt died in 1945, every justice who was on the Supreme Court had been nominated by him. Obviously, George Washington nominated the entire first Supreme Court. In recent years, until Donald Trump, the trend had been two nominees. For example, Barack Obama nominated two Supreme Court justices, Kagan and Sotomayor. Before him, George W. Bush nominated two Supreme Court justices. Before him, Bill Clinton nominated two to the court. Donald Trump is the first president in quite some time, in fact, since Ronald Reagan, to nominate more than two justices to the court. And Ronald Reagan nominated four of the nine justices to the court, although, again, he did it over 8 years, as opposed to Donald Trump, who has had three nominations in just his first term, which is pretty rare. So the second overview, president's impact on the court is unknown until after he leaves office. The third overview is the founding fathers intended. They believed that the judiciary would be the weakest branch of the national government. In the first section of the course, I talked about the Federalist Papers, and Alexander Hamilton in the Federalist Papers said that the judiciary would be, quote, the least dangerous branch. And the reason that Alexander Hamilton believed this is because all courts lack the two most essential powers of government, which are the power of the purse, taxing and spending, which belongs to Congress, and the power of the sword, raising and using a military, which belongs to the president as commander in chief. The courts also lack the ability to enforce their decisions. And I mentioned this one, I believe, earlier, but I'll repeat it because it is an incredibly important historical example. There was a significant battle over whether Andrew Jackson had the right to relocate Native Americans, mainly Cherokees, but also Seminole and Choctaw and some other tribes, from the southeastern part of the United States to Oklahoma. The case ended up, of course, before the Supreme Court. And John Marshall, you may remember John Marshall. John Marshall ruled that President Jackson did not have the right to relocate these native tribes from the southeastern part of the country. And Andrew Jackson's famous response was, well, John Marshall has made his decision. Now let him enforce it. And of course, he couldn't enforce it because the military was answerable to Andrew Jackson, and Native Americans were relocated. Also, keep in mind the example I gave you earlier that southern states refused to implement desegregation efforts, even though the U.S. Supreme Court, in the landmark Brown versus Board of Education decision, said that public school segregation was illegal and you must desegregate with all deliberate speed. And southern states essentially gave the middle finger to the national government. They refused to implement it, and the Supreme Court was powerless to enforce that decision. Now, eventually, Congress intervened. Congress put tremendous financial incentives into compliance, and in the end, desegregation did occur, but it was really over a decade that went by before meaningful desegregation occurred in the Deep South. The fourth overview that is mentioned in your notes is the Supreme Court is the most trusted institution in American government, even though it is the least democratic. And this has been true now for several decades, for approximately 50 years. And to me, this is kind of a sad statement, maybe even a slightly dangerous statement, because the Congress, which is the most democratic institution, is the least trusted institution. The U.S. Supreme Court, an institution that we the people have no direct control over at all, is the most trusted institution. And to me, this is kind of an indictment about ourselves. The institution we do have control over, we don't trust. The institution we don't have any control over at all, we do trust. And so that's, to me, it's a rather frightening. It is a frightening kind of statement, I think, on our part. The last of the overviews is that even though in these lectures I'm going to emphasize the U.S. Supreme Court, I do want you to realize that the U.S. Supreme Court is the only court that is created by the Constitution. So on the exam, if I ask you, the Supreme Court was created by, your answer on the exam would either be Article 3 of the Constitution, it might just be the Constitution. But I mentioned a few minutes ago there are 107 other courts, which we tend to call the federal court system. And the lower courts, the U.S. Court of Appeals, the U.S. District Courts, were created by Congress in the Judiciary Act of 1789. So those are the five overviews, right? The five overviews are the Supreme Court's a political institution in all aspects, that a president's impact on the court is unknown until he leaves office. The founding fathers intended, they believed that in this particular case, the courts would be the weakest branch. If I ask you that on the exam, and I think there is a question. I've already started putting the test bank together for exam 2. I think there is an exam question that says the founding fathers believed the judiciary would be the blank of government, the strongest, the weakest, or about equal in power, and they believed it would be the weakest. The Supreme Court is the most trusted national institution, even though it's the least democratic. And the U.S. Supreme Court is the only court that is specifically mentioned in the Constitution. All of the lower courts were created by Congress. And so the answer, if I ask who or what created the U.S. Court of Appeals and the U.S. District Courts, who or what created the federal court system, your answer is either going to be the Congress, if that's the answer, or the Judiciary Act of 1789, if that is the answer. So those are your 5 overviews. 2, jurisdiction. When we talk about courts, the place we have to start is jurisdiction. You should know this. You should put stars next to it. Jurisdiction is merely the authority of a court to hear and decide certain cases. So there are 2 elements to jurisdiction. The first one, I think all of us are familiar with, right? So the first type of jurisdiction, I don't even have this written in the notes because I think this is something we all know. The first element of jurisdiction is, are we dealing with a federal crime or a state crime? So for example, if I got a printing press operating here in my home and started counterfeiting money and I got caught, I would be tried in U.S. District Court in Fresno. That's a federal court because counterfeiting is a federal crime. So I would go to U.S. District Court. There would be a trial. I would be found guilty, and they would send me to a federal prison. So counterfeiting, federal crime, federal court, federal prison. On the other hand, let's say that I did not engage in counterfeiting and instead I went to a local convenience store, which I call a stop and rob. And let's say that's exactly what I did. I went there, held the place up, robbed them. Well, that would be a state crime. So I would get caught. I would go to the local superior court, which is here in downtown Merced, where I live. They would try me in superior court, and I would end up going to state prison for my crime. So one element of jurisdiction is, well, who has the authority to hear this case? Right? Federal courts hear federal cases. State courts hear state cases. People who are found guilty of state crimes go to a state prison, and people who are guilty of federal crimes go to a federal prison. So that's part of that element. Remember about federalism, which was our last topic in this particular case. So court systems are concurrent powers. The federal government has the power to have a federal court system, and all of the states have a state court system. Just as the U.S. Supreme Court is the top court in the federal court system, every state also has a Supreme Court. Interestingly enough, a couple of states actually have 2 state Supreme Courts, but that is something that goes well beyond this lecture. If you're interested in Texas, I believe, is one state that has 2 different Supreme Courts. I'm thinking Arkansas might be the other. I haven't seen this for quite some time. Anybody who's interested can probably Google in what states have more than one Supreme Court. But the notion is that the Supreme Court is the supreme law of the land. The U.S. Supreme Court is the supreme law of the land for both state and federal cases. It is supreme over both state law and federal law, and we'll get into that discussion more later. That's the end of the overviews. We will start the regular lectures with an example of jurisdiction next time. Have a great day, everyone. Take care. Bye.